Governments usually recognize certain basic rights, like the right to life, free speech, or property. But what if governments didn't recognize these rights? Would that translate into a lawless and violent society? What if there was no state at all? Does that mean there's no law or that we have zero rights?
For hundreds of years, thinkers have tried to answer this problem, attempting to understand the origin of laws and rights that would predate not only the state, but also societies themselves. One answer is found in the concept of natural law, which holds that there are universal laws to which all humans are bound.
Welcome to Libertarianism.org's Learning Hub, an introduction to the concept of natural law. The natural law doctrine argues that there are certain natural principles based in nature that all humans and societies are bound to. Not unlike the insights of science, natural law theorists maintain that laws are not invented, but actually discovered or revealed. According to Professor M.B. Crow, natural law, as an idea, is almost as old as philosophy itself.
For example, the Greek philosopher Heraclitus wrote that all the laws of human beings are nourished by one divine law, justifying all human laws as aspects of divine nature. Plato believed that the law of nature was eternal and immutable, and that we discover its principles through reason. Later, the Roman writer and philosopher Cicero argued that true law is right reason in agreement with nature. During the medieval period, Thomas Aquinas was the most well-known proponent of natural law. In Summa Theologica, Aquinas maintained that natural law was part of the eternal law of God, and legal rules, lex, were applications of reason aligned with the natural law for the common good. During the Enlightenment, John Trenchard and Thomas Gordon stated in one of Cato's letters that laws need to be in accordance with nature and reason. If they are not, breaking them is not a crime. By contrast, if an action violates nature and reason, it is a crime, even if there is no law to enforce it.
Although the concepts of nature and reason are common to most natural law theories, there are many nuances that have emerged throughout the centuries. Some theologians believe that natural law is better understood as absolute prescriptions decreed by God and discovered through revelation instead of pure reason. Others, called traditionalists, like Aquinas, compared natural law to moral duties, and freedom was understood as a right not to do whatever you want to do, but to act as you ought to. You can read about these thinkers and much more at Libertarianism.org, but for the purpose of this video, we're gonna focus on John Locke's work on natural law.
In his famous Second Treatise of Government, Locke theorizes that, to understand the justification and limits of political authority, we need to look at people in the state of nature, that is, before political societies were formed.
For Locke, natural law, divine in nature, exists and governs the state of nature. And reason helps us discern its principles, which then apply to all. More specifically, Locke believed that these natural rights derived from divine law consisted primarily of self-ownership, or property of your own person. That's why, when Locke talks about property, he's not referring to an estate or material things, but it includes one's life and liberty.
When men leave the state of nature, for example, to form a society, individuals can consent to waiving their private right to act as executors of the law of nature and vest it in a political entity to enforce it. However, if this government infringes on these rights it's supposed to protect, it would lose its claim to authority and could be replaced.
If this sounds familiar, it's because Locke was a big influence on the founding fathers during the establishment of the United States. For example, in the Declaration of Independence, we find several references to the concepts we've learned today.
We hold these truths to be self-evident: that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. whenever government becomes destructive of these ends, it is the right of the people to alter or to abolish it.
In sum, the natural law doctrine maintains that there is a law based in nature that all humans and societies are bound to, with no explicit need for consent or a government to enforce it. Are all natural law theories theological? Have there been attempts to develop this concept without the religious component? The answer is yes. We invite you to read through our resources and visit Libertarianism.org for answers to these questions and much more. And if you like this video, please don't forget to like, comment, and subscribe to our YouTube channel.